Yo, folks. Did Brian Tully's attorney file AI case law in his motion to quash his subpoena? It seems he did. And we really didn't discover it until he filed a correction. Welcome to the show.
Santa Claus, riding in with the winter laws. Santa Claus, streaming live for the roaring masses. Go, 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 raise them horns, old Judge King in a crown of thorns. Santa Claus, streaming live for the roaring masses. Santa Claus, Santa Claus, Santa Claus, Santa Claus.
Yeah, you'll see my shows when I go through these documents. I read almost all the pages, but often I just skim through the cited case law because I, as many others, we seem to not be caught up with how far this AIBS case law citing has become. Whatever. Especially in a case like this, it's national coverage, international coverage. To be that lazy, to be that dishonest with the court. Now, I didn't personally find this because of reasons, but Adam Scott on X did. He says, I really don't think enough is being made of attorney Timothy Burke filing a motion to quash his client. Well, here he writes Proctor, but it's actually Tully. Deposition using AI and citing a case that not only doesn't support his legal argument, but does not even exist. And how did we find this out? Well, I do believe not until because Mr. Burke filed a motion to correct. That's not uncommon. And his motion to correct was regarding, well, he said he just had to correct a citation. And for me, that means, okay, he misspelled something. Or there are 2 or 3 different case laws with a similar name, but different years. You know, I mean, there's a lot of case law out there, so it happens. But when we go through his correction here, then it becomes obvious. Non-party witness Brian Tully, retired. Through counsel, respectfully submits this supplemental notice to clarify and supplement the motion for leave to file a corrected memorandum previously filed in this matter regarding a citation in the memorandum of law filed in support of his motion to quash subpoena and or for protective order. The prior motion for leave to file identified the citation to McGuire v. Cunningham, appearing on page 6 of the memorandum, was incorrect and should be replaced with Cronin v. Strayer, 392 Mass 525, pages 534 to 535, from 1984. That folks, that's not misspelling. That's not, it's 2 similar named case laws with different years. It's completely different. Absolutely completely different. Counsel files this supplemental notice to state plainly for the completeness of the record that upon further diligent review, counsel has been unable to locate any reported decision corresponding to the citation McGuire v. Cunningham. Counsel does not believe any such case exists at that citation. So he filed this Somebody must have noticed, told him, and then he like, oh, I'm filing for correct to correct the record. Which means he didn't even proofread his original motion to quash. Counsel identified this error through counsel's own subsequent review of the citations in the memorandum prior to any inquiry from the court or from opposing counsel. This is Mr. Burke trying to save his ass. Well, nobody noticed it, so I did it all on my own. All on my own. Well, somebody had to have noticed, because you don't file first and then proofread. So my guess is he just asked ChatGPT or whatever's, write something for me, and then just filed it with the court. That is my guess. Let's continue. Brought it to the court's attention promptly thereafter by means of the original motion for leave to file a corrected memorandum. Counsel files this supplemental notice to ensure that the record before the court is complete and unambiguous. As stated in the original motion for leave, the requested substitution of Cronin v. Strayer for the erroneous citation does not alter the legal proposition for which the citation was offered, the argument advanced in the memorandum, or the relief requested in the motion to quash subpoena and or for protective order. Again, this is him trying to save his ass. Whoopsie, sorry. But at least he did. At least he did. So less of on the minus side, but still on the minus side, because he didn't proofread his own motion. And regardless of this, in his motion, he stated that Brian Tully was barely involved in this case, which is an outright lie. Let's go through a bit of what Brian Tully did in the Karen Reed case. Okay, first of all, supervisory head of the MSP detective unit assigned to the Norfolk County District Attorney's Office. He took the witness stand to discuss evidence collection. He introduced cell phone location data and antenna mapping. He oversaw he oversaw the extractions. He didn't directly participate, but it was his team who did everything in the Karen Reed case. More or less, what Proctor saw, what Proctor gathered, Tully supervised. That makes him, in my opinion, not only indirectly involved, but directly involved, especially since he testified at the trial. So, which makes Mr. Burke's motion and even him changing out the case law, in my personal opinion, flawed at best, disingenuous, or right out false. Now, will we see Uncle Bev making a ruckus out of this? I don't know. But it will be a litmus test for Judge Uncle Bev to see, is he only wording out against the Karen Reed team, or is he prepared to actually do something about the rest of them? That is what I had for you. You all have a good one, and I will see you in the next stream or video. Bye-bye.
Santa Claus, riding in with the winter laws.